Donald Trump has just filed a notice of appeal to the D.C. Circuit Court of Appeals regarding Judge Tanya Chutkan's order denying his motion to dismiss on absolute presidential immunity grounds. I'm Ben Meiselas. This is the MeidasTouch Network. And in addition to filing that notice of appeal, Donald Trump also filed a motion to stay the pending proceedings in federal court, Washington, D.C., before Judge Tanya Chutkan, on the grounds, Donald Trump argues, that an interlocutory appeal, a direct appeal to the D.C. Circuit Court of Appeals, requires an automatic stay, an automatic pause of the proceedings in the district court. And remarkably and unlawfully, Donald Trump states in this motion for a stay that regardless of what Judge Tanya Chutkan is doing, Donald Trump says that Trump will proceed based on that understanding and the authorities set forth herein absent further order from the court. In other words, Donald Trump is saying right there that he is not participating anymore in the D.C. federal criminal case. Unilaterally, he's saying that based on his understanding of the law, which is flawed, he says that he will not be participating. He's not going to file motions, not going to engage in any of the proceedings before Judge Tanya Chutkan. Folks, let's break all of this down. Here's the notice of appeal that Donald Trump just filed. Says defendant Donald Trump, his lawyers refer to him as president. We don't do that here on the MeidasTouch Network. If they wanted to say former president, fine, but the defendant Donald Trump hereby provides notice that he appeals to the U.S. Court of Appeals for the District of Columbia Circuit from the memorandum, opinion, and order of the District Court from Judge Tanya Chutkan, dated December 1st, 2023. Donald Trump's notice of appeal is dated December 7th, 2023. We covered that order on December 1, 2023, where Judge Tanya Chutkan says Donald Trump, as with all presidents and former presidents, are not kings. Donald Trump is not the president, and there is no absolute presidential immunity at all, even within the outer rung or outer bounds of potential Article 2 conduct when it comes to criminal behavior of former presidents. Remember what also happened on December 1 earlier that day, where the D.C. Circuit Court of Appeals, in a case that is called Blassingame, made the ruling regarding civil cases, the application of absolute presidential immunity in civil cases, not criminal cases, found that Donald Trump's behavior relating to the January 6th insurrection fell outside the outer bounds of Article 2 roles and responsibilities of presidents or former presidents, because Donald Trump was engaged in campaign activity, not activity of a commander-in-chief or that of a president. So that all happened on December 1st. So we've said here on the MeidasTouch Network that when it comes to issues of immunity, specifically the absolute presidential immunity doctrine, there is a right to have an automatic appeal to the D.C. Circuit Court of Appeals, which oversees the federal court in Washington, D.C. You'll recall from another hot take that we did where we discussed all of these issues. It's why Special Counsel Jack Smith filed a notice to the court saying that you should adjudicate the issue of presidential immunity first and right away, because Donald Trump does have a right to appeal that, and he's certainly going to play games with that. So Judge Chutkan make a ruling on that. Judge Chutkan made the ruling on that on December 1st. Now, what Donald Trump is arguing is, in addition to the appeal, he claims, based on two cases that he cites in this motion for a stay, and on that basis says he's not even participating in the criminal case anymore. He's not showing up. He's not doing things. He's not going to even respond to Special Counsel Jack Smith. That's essentially what he's saying here. He's saying based on these two cases, the D.C. federal case involving his attempt to overthrow the results of the 2020 election, which is scheduled for trial in March of 2024, where jury notices are already starting to go out and questionnaires are going to be going out soon, Donald Trump says that must be halted, that must be stopped or paused or stayed until the D.C. Circuit Court of Appeals finally adjudicates the issue of absolute presidential immunity in a criminal case, and only upon that adjudication of Judge Chutkan's order going to the D.C. Circuit Court of Appeals, only when that is resolved can the case in federal court, Washington, D.C., continue to proceed to trial whenever that is. In other words, Donald Trump is this. We said he was going to do this, delay, and try to block the D.C. case from proceeding to trial on March. It's all a delay tactic, and that's why he said he filed those flurry of motions to dismiss, not because he thought he was going to win, but when he lost, he wanted to make the argument that should somehow derail and stay and stop the federal trial from going forward in March of 2024 until the D.C. Circuit Court of Appeals hears his frivolous appeal on the issue of absolute presidential immunity.
Did you know that poor sleep can cause weight gain, mood issues, poor mental health, and lower productivity? Sleep is the foundation of our mental and physical health and performance in our days. Having a consistent nighttime routine is non-negotiable. When I don't get enough sleep, trust me, you don't want to be around me the next day. Introducing Beam Dream. You know we've been raving about Beam's Dream Powder, their healthy hot cocoa for sleep. And today, my listeners get a special discount on Beam's Dream Powder, their best-selling healthy hot cocoa for sleep with no added sugar. Now available in delicious seasonal flavors like cinnamon cocoa, sea salt caramel, and white chocolate peppermint. Better sleep has never tasted better. Dream contains a powerful all-natural blend of reishi, magnesium, L-theanine, melatonin, and nano CBD to help you fall asleep, stay asleep, and wake up refreshed. A recent clinical study revealed Dream helped 93% of users wake up feeling more refreshed, and 93% reported that Dream helped them get a more restful night's sleep. Just mix Beam Dream into hot water or milk, stir or froth, and enjoy before bedtime. I've personally tried Beam Dream. It certainly lived up to the hype. It was delicious and just a lovely nighttime routine. And secondly, and most importantly, it helped me fall asleep and stay asleep. Find out why Forbes and the New York Times are all talking about Beam and why it's trusted by the world's top athletes and business professionals. If you want to try Beam's best-selling Dream Powder, take advantage of their biggest sale of the year and get up to 50% off for a limited time when you go to shopbeam.com/legalaf. The discount is auto-applied at checkout. No code necessary. That's shopbeam.com/legalaf for up to 50% off.
And when I say a frivolous appeal, we now know the D.C. Circuit Court of Appeals has ruled, has established precedent on the issue of absolute presidential immunity related to Donald Trump, surgically related to him in his conduct relating to the January 6th insurrection and surrounding thereof. How do we know that? On December 1st, they issued the ruling in Blasingame versus Trump. Remember, I said that earlier in the video, where they found that there was no absolute presidential immunity in a civil context. So if they found there to be no absolute presidential immunity in a civil context, the criminal context, they clearly are not going to find absolute presidential immunity for former presidents in a criminal context. They've established that precedent already. Nonetheless, in this motion for a stay, and it's an opposed motion for a stay, Special Counsel Jack Smith is opposing this motion. Trump's lawyers cite Blasingame, the case that says he has no absolute presidential immunity, as the basis for his stay request. Take a look. Donald Trump cites two cases right here. It says Donald Trump respectfully submits this motion for an order enforcing an automatic stay of all district court proceedings, in this case, pending the final resolution of his recently filed appeal from the district court's December 1, 2023 ruling on, inter alia, among other things, presidential immunity and double jeopardy. The filing of Trump's notice of appeal has deprived the court of jurisdiction over this case in its entirety, pending resolution of the appeal. Therefore, a stay of all further proceedings is mandatory and automatic, Donald Trump argues. And he cites Blasingame v. Trump and another case called Coinbase versus Bielaski as the basis and as the precedent. Let me be clear. Coinbase versus Bielaski, that case right there involved an arbitration provision and the determination on arbitrability. And there the Supreme Court held in a ruling in June of 2023 that because arbitrability is a threshold matter, that the district court case itself needs to be stayed pending resolution on an appeal regarding the issue of arbitrability. It didn't, and the concept of arbitrability is a well-established concept and principle. And so that case, though, does not involve presidential immunity. It involves arbitration provisions. Then Donald Trump cites Blasingame to stand for the proposition that merits-based discovery should not proceed in a civil case as a basis for an automatic stay in a criminal case. Blasingame stands for the proposition that Donald Trump's appeal is certifiably frivolous, yet Donald Trump is citing the case that states that he has no absolute immunity as the basis for why the district court case before Judge Tanya Chutkan should be stayed while he appeals the issue of absolute presidential immunity to a court that just ruled he has none. That is the absurdity of what Donald Trump is requesting. And you see right here, it says, last week in Blasingame versus Trump, the D.C. Circuit made clear that official immunity issues must be resolved prior to the litigation and discovery on the merits. Imagine that. Trump citing Blasingame for the proposition that official immunity issues must be resolved prior to litigation and discovery on the merits, when he didn't say, well, actually what Blasingame stands for the proposition is that you don't have official immunity in this exact context. Then Trump goes, thus, in addition to the lack of jurisdiction, Blasingame requires the court to stay all proceedings in this matter pending appeal, including but not limited to pretrial motions, defense disclosures relating to trial defenses and evidence, SEPA hearings, and jury selection. As a result of these authorities, all current deadlines must be held in abeyance until, at a minimum, the motion to stay is resolved. And then Trump says, Trump will proceed based on that understanding and the authorities set forth herein, absent further order from the court. Trump saying he's not going to be participating in SEPA hearings, jury selection, trial, defense, and evidence, that he's out. He's not participating. So now expect a scathing order from special counsel Jack Smith. Expect Judge Chutkan to come down on the mark. You can't just say, I'm not participating in the case absent a court order. But this is a direct challenge to Judge Chutkan's authority here. We will keep you posted on what's going on and what the next steps are, but that's where we're at right now. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers thanks to your support.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.